matters. And we're also on the panel for WA Apartment Advocacy, so giving advice on the Strata Titles Act. I would like, first of all, to thank again Paul Einarson and St John for allowing us to hold this function here in their premises. The purpose of this seminar, and thank you very much for enrolling and coming along this evening, is to give you an introduction to the State Administrative Tribunal, what that body is, the types of matters that they deal with, and how complex or simple it is to make an application and run your case through the State Administrative Tribunal. We're very fortunate this evening to have Mr. Peter McGowan, very senior counsel of Francis Burt Chambers, along. I've known Peter for quite a number of years, and I've printed out his biography and his specialist areas. We use and have used Peter on a number of cases, very successfely. We've had, and rather than read his bio, I'd like to just briefly touch on some of the cases and successes we've had with Peter. We've explained the case that we've currently got before the State Administrative Tribunal, and rather than that case being dealt with by a sessional member, Peter structured it so that it's before a judge in the SAT, because we want a judge's decision on the interpretation of that section of the Health Act. Naturally, that has huge consequences for our client, who has a long-term lease of these business premises, who did everything and got all necessary approvals to operate their business, and now have been told by the City of Vincent, after undertaking the works that the City of Vincent required to try and remediate the smell, to say, stop trading. Another case that we have is, we have a case that is probably going to end up in the Supreme Court, where we act for a property developer. Another property developer constructed roads. Our client also developed land adjacent to the roads and actually ceded land to for the creation of these roads and roading intersection, and gave up land. And then the first developer has come along, as they're entitled to do under the Planning and Development Act, and sought a contribution of 50% of the cost of the construction of the roads from our client. Our client actually says, no, we already gave, and we've contributed land. And interestingly enough, the case on point is a Court of Appeal decision where Peter acted on it. So they're claiming over $600,000 from our client, and I suspect that we were very fortunate to get Peter on our side of the matter, and I suspect that that matter is going to go before the Supreme Court. Another case that Peter doesn't know about at the moment, but which is likely to be referred to him as a situation where our client, the day before our client was due to settle a purchase of a residential property, the solicitors for the seller gave us notices from an adjoining owner saying they were going to, that the adjoining owner was going to make an adverse possession claim against part of our client's land. They weren't the landowners at the time, though. They were due to settle the next day. So that's going to be a very interesting claim, whether or not they have a valid adverse possession claim against our client. In the past, Peter's appeared for us in a case, in actually a number of cases where our clients have bought businesses and been induced to enter into agreements to purchase businesses by representations or misrepresentations made by these business sellers. And our clients have purchased the businesses, and they're not doing anywhere near what it was represented to them that it would do. And so one particular case, Peter acted for us, and we were very successful. We got judgment against the business sellers and their mother, who was involved in it. And not only that, we got the damages were paid within a week, over $500,000 back for our clients. That was a very interesting case, because on that case, and that's why we use Peter, because 90-something%, I believe, of cases don't go to trial. So when you're a solicitor engaging a barrister, you want to look for a barrister who has advocacy experience before the courts, the Court of Appeal, the Supreme Court, the District Court, not so much the Magistrates Court, but also the State Administrative Tribunal. Correct me if I'm wrong, Peter, but a lot of barristers these days don't have that experience because their matters don't go to trial. Therefore, how do you judge whether or not that barrister is good on their feet, is good at examining witnesses, cross-examining witnesses, summing up the case? We've been very fortunate to have Peter, who has that hands-on experience in trial advocacy, and it's extremely important. And when you watch somebody like Peter, who has those skills, going up against a person who doesn't have so much advocacy experience, it really is telling, and we are so thankful to have him on our side. We've had quite a number of cases where we've had used other barristers in the Supreme Court. Then, for whatever reason, we've had to terminate those engagements and got Peter on board and managed to bring the matter to fruition. Other cases of the Little Black Book, buying a business based on representations in the Little Black Book, which they then denied ever existed. Both of those cases we were successful in. So it's extremely important, and I can't impress upon you enough how important it is when your lawyers are looking to engage a barrister, making sure that that barrister covers the specialist area concerned and also has advocacy experience in the highest courts. Because court and going to court is not cheap, going to SAT is not cheap either. So you want somebody on your side who you can ask questions of and they'll actually give you an answer. Not the usual lawyer, well, it could be this, it could be that, it's a bit grey and that sort of thing. You want some proper guidance from your solicitor and your barrister. You want to know before you launch into this, what do you think my prospects of success are? So you need to really bear that in mind. And Peter is that advocacy trial experience barrister. So I can't speak highly enough of him. So you can read his bio, you can see the specialist areas he works in, and yeah, if you have any questions, I'm sure we can take those questions later on. But Peter, over to you.
I'm going to stand up first quickly, if I may. Okay.
Sure.
But thank you, Martin. I appreciate that. Now, I have been told to kind of like give you some brief outlines, of course, of what's happening. So if you hear an ambulance nearby, don't worry. This is a working depot, obviously. So Paul said that they can have up to 100 ambulances coming through in here. If you hear the alarm to exit the building, we need to meet across the road. And if you need to go to the toilet, just go down the corridor and go into the relevant gender. The lights will come on automatically when you enter in, okay? So some of you already know about us because you've been in my Zoom events or you've come to my functions, or I've met you personally because I've come out to give you advice as well. So we represent 2.5 million people in Australia, 10% of the voting public, which is awesome. We do a number of things. This is the education kit that we've created for apartment buyers and owners. I have brought copies, so please take one of those with you this afternoon as a bonus if you haven't already received that. We obviously do research, we lobby government. We're actually calling a government at the moment to create an apartment reparation fund for people who've actually got defects and their builder has gone bust, because then they have to pay for the defects themselves. We do an apartment awards, and I'm saying that because there's an actual category for council of owners. So it's called a People's Choice. We're launching that on the 8th of February. If you believe that your building and what you do in your building is exceptional and amazing, then please enter the awards. We had City Towers win last year and it was amazing for them. And also then, what was the one? Panorama won the Enduring Award. And I think it's a really great feeling because both of those spoke at our conference. and they felt such a sense of pride. So if you're doing something really amazing, then please let me know afterwards, and I'll send you the awards kit, and I won't charge you to enter, because I'm actually very keen to promote great straters who are doing a really good job. All right, so I'm going to hand across to Peter to talk about SAT 101. If we can keep this as relevant to apartments as possible, please, that would be great. And also, not too much lawyer jargon, please, darling.
And you're actually allowed to stand there and talk to us.
Now, Peter, do you want to click the clicker, or do you want me to click the clicker for
You
you?
can click it for me.
Okay.
Good evening, everyone. Thank you very much for coming along. I hope I can inform you about something that's relevant to you. I should begin with a couple more disclaimers. First of all, despite my name, I'm no relation to the Premier. I know we're all anxious about the 5th of February, but my name gives me no insight. I've got no clue. I can also add that my son and his family live in Sweden, so I have a fair bit of understanding of how they've handled COVID. Now, this evening's presentation is primarily, as the title suggests, to do with SAT 101. That is an introduction and explanation of what the State Administrative Tribunal does, both in terms of its objectives as prescribed in the Act, and also to explain with some examples how it's dealt with particular matters. And despite the many years I've been in practice, I'm still yet to come to grips with ultimately whether SAT is achieving its purpose or not, but it's still a work in progress. I should also add that in 2003-2004 I was the Foundation President of the Town Planning Appeal Tribunal, the relevance of which is that at the end of that year the government abolished the tribunal and I went back to the bar, and what became the State Administrative Tribunal absorbed the functions of the Town Planning Appeal Tribunal, as well as a whole host of other tribunals, so it became the umbrella tribunal for what previously had been something like 70 separate tribunals from any number of acts operating throughout the state in relation to all manner of things that you could possibly imagine. And so in many respects, the procedures that you now see or take you to in the SAT come from the Town Planning Appeal experience. Now, taking up Sam's exhortation that I should try and keep this as relevant to apartments as I possibly can, which I'll try to do, and I fully understand that not only is apartment living a critical aspect of things so far as they relate to those of you who are here tonight and those who are watching online, there is within the State Administrative Tribunal a dedicated strata stream, that is, for matters which involve issues arising under the Strata Titles Act. There is a dedicated member or members who are allocated to deal with those particular matters. And so that what you get from the definition and constitution of the State Administrative Tribunal is the identification of, first of all, the fact that it's not a court, it's a tribunal. And that's not just a change in name, it's a fundamental change in the nature of what they're doing. The second thing is that although in some respects if you ever went there it appears to have the trappings and formalities of a court, it really is that superficial aspect. You shouldn't be deluded by that. The substantive operation is really governed by its own act, where SAT is obliged to review or make decisions fairly and according to the substantial merits of the case, and to act as speedily and with as little formality and technicality as is practical, and most importantly to minimise the costs to the parties. Now, all of those are important themes to understand the nature and role of SAT as we progress through this stage, to understand where it might fit in as far as you are concerned or those with whom you have contact. It's also important to note at this stage that within SAT's own act, its purpose is to produce the correct and preferable decision. In other words, it's not bound by the laws of evidence, it's not bound by strict formality. Its desire is to get to the heart of the matter and come to an answer which is both practical, sensible, and ultimately preferable. And in the context of the disputes I'm sure you have in mind, that probably squares for the moment. Now you have the membership of SAT consists of the president, who has to be a Supreme Court judge, a deputy president, who must be a judge of the district court, and then senior and ordinary members. I don't mean that dismissively, that's just the title. And in that regard, it's quite important to emphasise, consistent with the rationale and the existence of SAT, that the membership, that is the senior and ordinary members of the tribunal, are more often than not drawn from people who have relevant experience in the areas with which SAT primarily deals. And those mainstreams are strata titles, commercial, planning and development, guardianship and administration, and vocational. There's also a stream that deals with the Dog Act, but I don't think we need to worry about that too much, although it may be of some concern. So you find if you go to the SAT website and look up the members of SAT, you will find a number of people. So for example, in the vocational stream, that means if you make a complaint about the conduct of a lawyer or a doctor or an engineer, you will find amongst the membership members of those respective bodies that sit on the tribunal to deal with disciplinary complaints. In the same way, in the guardianship and administration stream, you find people who've been qualified social workers, doctors, psychologists or psychiatrists, and play a legitimate and proper function in that regard. In the planning stream, you'll find, in addition to any legal member, members who've either been planners themselves, architects, or people with similar backgrounds. And of course, in the building stream, you've got builders, engineers and architects as well. All right, so what's SAT used for? So I've given you, as an overview, the various streams that identify the way in which SAT operates. That is, it divides itself into areas which correspond with areas of expertise, consistent with the structure and purpose of the tribunal to get to the heart of the matter. And how better to get to the heart of the matter than have someone who has the relevant background and experience to help the tribunal get to that result. In times past, you might have expected that to be the subject of expert evidence and call for an expert. How much better it is to have the expert in the room, so to speak, to make the expert a part of the decision-making process, which cuts down the need to go to the whole process of engaging expert witnesses and so on. So, can I then take you to one of the examples? Come back.
The previous, the second one.
Just want to, we get that some? Back. Back.
Yep.
All right, so here's an example. So as part of the amendments to the Strata Titles Act, which came into effect in May last year, was to expressly provide for a definition of what's referred to as a scheme dispute. And provided your dispute falls within a scheme dispute, then those disputes are capable of being referred to SAT for determination, either because you've got problems with the council, or because you've got issues between owners, or because there's a whole variety of matters. But provided you fall within the definition of scheme dispute, we'll come back to it in a minute, then you can be off and running to go to SAT. Now, I just want to go sideways but forward at the same time, if that makes some sense. One of the things which I'm sure you're aware of, which was part of the suite of amendments that came into effect in May last year, was the need for all strata companies to have a 10-year plan. And as part of that exercise, what's required is for the company to provide for estimated costs for maintenance, repairs, renewal or replacement of the common property and the personal property to which the plan relates. Now, that's quite a significant obligation, and in many cases I suspect that is a novel obligation, something which hasn't hitherto been addressed. And inevitably it seems to me that once that obligation is embraced and understood, it means, now getting to the question of building, it means that you're now dealing with a thorough review of the building, including in particular ageing aspects of the building, the implications for the purpose of renewal or redevelopment, and consistent with the need for a 10-year plan, a plan that demonstrates how that's going to be achieved. Now, part of that process, and it'll cut two ways, part of that process will be to address whatever work may have been done that has taken the building, common property, etc. to this point. The second part is the need to engage a builder, in all likelihood, to carry out whatever the plan may require. Now, both of those matters, that is, looking at past building and the engagement of builders for the future, raise the question of how to deal with any defects that might arise, either historically or prospectively. And I want to give you some examples, trying not to be too legalese, to illustrate some of the points that might be absorbed. Now, the first is that if you have, that is you, the strata company have, or an individual owner of a unit, has an issue in relation to the building, common property or an aspect of it, and you would otherwise want to make a complaint about it or do something about it, you might find yourself in this legal conundrum. That is, I really don't want to get involved in litigation. I really don't want to find myself having to sue the builder. Isn't there some other means by which? And the answer is yes, and we'll get to how SAT gets involved in a second. And the means by which in the first place is that you have the capacity, if you're a person affected, to make a complaint about that building defect to the building commissioner. And the building commissioner's function is to investigate that complaint, send out the building inspector, do a review, identify the issue with the builder, and then create a pathway ultimately, if the building commissioner finds that that's a condition, to make a building remedy order, either order that the work be carried out to fix it, or in some cases to make a money order if the builder refuses to, or if it's appropriate not to, order the builder to carry out the work. The builder can instead either agree to or have imposed on him, in effect, a monetary penalty, the cost of fixing it. Now, the point about that is this. You don't need to be the contracting party to make that complaint. Right? If you think about the context in which building work ordinarily occurs, a builder will be engaged. That is, there'll be a building contract, and the contract will be between the builder and whoever it is that the builder is carrying out the work for. And when you consider that you might have moved into your apartment after the building was built, you're not the person, and the strata company in many cases is not the party with whom the builder contracted. So ordinarily you think, well, we're stuck, aren't we? If we didn't have the contract with the builder, how can we bring any action against the builder? And that's where this pathway under the Building Service Complaint and Resolution Act comes into effect, because provided it can be shown that you've got the person who carried out the work, the regulated building service provider, and provided you can show that the work has not been carried out in a proper and proficient manner, or it's faulty, or it's unsatisfactory, you're off to the races. You don't have to have a contract, you just need to be able to demonstrate that connection. Warning, it has to be within 6 years of the work having been carried out. So that's the first point to observe. The second point about that is that if you have a more complicated situation, and I'll explain the situation to you now. There was a case in which I was involved that went to SAT about 8 years ago, which involved the development of a complex in Newcastle Street in Northbridge. The builder was Pizarros, who were no longer with us, and the development was a development called Times Square. Anyway, so it was a reasonable sized development, and sometime after the building had been built, issues emerged in relation to flooding in the car park. The car park was the bottom two levels of this development. Now, the car park is a critical aspect of anyone who requires an apartment. Obviously, you want the facility, if not the certainty, of having a car park, and the fact that it was being flooded really struck at the heart of the integral relationship between occupancy of the unit and the car that was parked underneath. Now, in this case, the complaint was made to the Building Commission by the strata company. It didn't have a contract with the builder, but it was the strata company now experiencing the problem. So it brought the complaint to the Building Commission. Building Commission says, as it can, well, this is too complicated for us, we'll refer this matter straight to the State Administrative Tribunal. So your building complaint goes from the Building Commission straight to the tribunal. Now, the point about this case is this. As it turned out, the builder, unsurprisingly, had relied upon geotechnical engineers, hydraulic engineers, and civil engineers, all of whom had played a part in the design of the complex and the works that lay underneath, including the groundwater level and how they would deal with it. Given, I'm sure you know, that Perth used to be surrounded by literally a chain of ponds, all of which were drained in the course of the development of Perth, and where they were in that area of Newcastle Street used to be a lake. And so being a lake, there were groundwater issues. Now, the point about that, the point about all of this, which I'm getting to, is this. If, in the conventional fashion, the strata company had brought an action against the builder in either the Supreme Court or the District Court, the builder, in the vernacular, in order to lay off liability, would then have joined the various engineers and say, well, if me, then them. And then there would have been a whole bun fight involving 5 or more parties, and the poor old strata company is then drowning in the cost of this whole exercise, when all it wanted to do in the first place was nail the builder. Now,
Good idea.
the point about these proceedings and the point about being in SAT is, when I say you, the builder can't do that. Once you've brought that complaint, provided it relates to an issue, using shorthand, of workmanship, the builder cannot bring in another party to the tribunal and seek to lay off responsibility or liability, and so create a complete uncontrollable train wreck. That didn't stop the builder, in this case I might say, from calling as witnesses who the builder intended to use to explain how it wasn't the builder's fault, to call up to, we had 7 engineers, and in the course of the hearing, all 7 engineers were present as witnesses, giving what's called concurrent evidence, which is sort of like a panel show. And it was that humorous. It was like an episode of Dr. Phil. So there was only one microphone, and there was need to raise the hand if one of the 7 wanted to speak, and the microphone was being passed around with identification of who was talking and what they wanted to say, and most of them seemed to be blaming each other. The long and the short of it was, and the point of all of this, is that in the end, the short point being made against the builder was made out. It was faulty workmanship, and therefore, as far as the tribunal was concerned, it was only ever looking at the builder and made a building remedy order against the builder to fix the whole exercise. The builder then didn't worry the strata company. The builder had to go off to the district court, bring its own proceedings, join the engineers, but didn't affect the building order that had been made. And that's probably an exaggerated example of how the tribunal can work to the way in which its statute requires it, and how in a practical sense it can provide a remedy to a strata company in relation to building defects, which is more immediate than might be contemplated by litigation. Now, just to sort of, I'll give you two other examples. The first of which doesn't concern a strata company, but it may well have, given the facts of the case. So in this case, there was a development of a complex set of group dwellings, and there emerged a significant issue in relation to a whole range of works. Same scenario. So the owners of the group dwellings together made a complaint to the Building Commission about the work, and they nominated as the builder a Mr. Holmes. Now, as it turned out, Mr. Holmes was a regulated building service provider, or as you would call it, a registered builder. And so therefore, Building Commission, when it received this complaint, looked up its register, saw that Mr. Holmes was on the register, recognised he was a builder, saw his name on some documents and thought, well, that must be it, and off we go. Looked at the nature of the complaint, referred to SAT, it was too complex. SAT, you deal with it. Much too complicated for us here at the Commission. Now, in the course of the hearing, Mr. Holmes, in effect, said, I've got nothing to do with it. And as it turned out, he was right. Because in fact, the people who carried out the work, who had dealt with the owners, didn't have enough indemnity insurance to get the license for this particular job. So they borrowed, using the word advisedly, Mr. Holmes' license. And although Mr. Holmes appeared nominally to be the builder, in fact it was these other people that did the building work. The tribunal found, therefore, that the complaint against Mr. Holmes had to be dismissed. Now, the last point I wanted to make about illustration of this area is to do with the simple question. You have an issue, say, with the driveway on your common property, and you wish that something would be done about it before someone either falls in it or someone's car is damaged as a result, or both. So the question is, you go to your council of owners and you've got a recalcitrant council. They don't want to spend money on anything. They're indifferent to your concerns. They don't do anything. So you, being an upright and responsible person, ensuring that harm is not going to come to people who might drive down the driveway or walk down the driveway, you decide to bring your own complaint to the Building Commission. So, put rhetorically, the question is, can you do so? And that was a question that came before the tribunal in a case which it decided earlier this year. And in order to decide whether you can make a complaint to the tribunal, to the Building Commission, you have to be shown to be a person whose interests are being or have been adversely affected by the carrying out of whatever work may have been involved. Now, it's hard to imagine if you're an owner and the driveway needs to be repaired in a significant way, that you could not be you could not be adversely affected by that fact. Not so, said the tribunal. The tribunal took the view that it was only the strata company that could take that position in relation to common property, on the basis that ultimately common property was the responsibility under the Act of the company, not the responsibility of the individual owners, and therefore there was no basis to contend that anybody except the strata company itself could bring that complaint to SAT. So that brings me back to section 197, which is what we've got here. And one of the issues which immediately arises is that in those circumstances, as happened here, where the tribunal had determined that it was only the strata company that could bring the complaint and not the individual owner, and therefore the claim failed because the individual owner didn't have standing, didn't have a right to bring the claim, what then was the remedy? And the answer is that you would then have a scheme dispute. If you've got a strata company who in those circumstances would not do what it was obliged to do, then there is a scheme dispute, and that you can bring to SAT, which can ultimately lead to SAT directing, in this case, that the strata company make that complaint and so properly generate the process. So that's where we get back to your interests in or of or connected with apartments, because ultimately it seems to me that in this area, particularly in relation to building defects and building disputes, the power of the individual, whilst it was denied in the sense of not being a right to bring a claim in respect of defects concerning common property, nevertheless is a power which is reserved to the owner under section 197 if you are dealing with a recalcitrant and unhelpful council of owners. Now, I've run through really there's that process, but let me just talk about one or two other things. First of all, one of the things which you will invariably raise is, do I need a lawyer? And the answer is no. And in fact, for many, many years, the tribunal has promoted itself as a forum where the need for legal representation is not encouraged. It's not discouraged, but it's not encouraged. And the sections that I took you to in the SAT Act earlier on about, in effect, the motto or the goal of SAT to achieve a correct and preferable outcome by the most effective and most cost-effective and efficient way is consistent with that. So that's not a concern. And certainly there are many cases, many cases, where in strata disputes, neither party is represented. And that's no impediment, particularly, as I've said, where there is a dedicated strata stream designed, at least conceptually, to be able to fast-track those sorts of disputes on the basis of the members' familiarity with and experience with the types of disputes that invariably come across people involved in strata developments. The second point is that SAT's processes are also heavily directed towards resolution. In other words, a substantive quasi-adversarial hearing isn't what SAT's primarily about. So if ever you find yourself involved in proceedings in the tribunal, invariably almost from the first appearance, there will be a direction that the parties go to mediation. Can't we get in a room and sort this out? And just going sideways for a moment, when I say mediation, it's strictly speaking not mediation in a true sense if there are lawyers involved, because necessarily if there are lawyers involved, it's more like guided negotiation. True mediation involves the mediator and the parties, and the mediator in effect having no agenda other than trying to resolve the matter and bringing the parties in a room stripped of their prejudices and whatever they're stuck with. Let's get down to what it is that separates you two. And I can readily understand why in strata disputes that would be almost the first and most obvious step that you would try and achieve. Although I think that by the time people get to the tribunal, they're probably so entrenched in their position and so necessarily adversarial in their approach, maybe beyond redemption. But that's not to say that that isn't how SAT tries to approach it. So this raises the question of why you would go to SAT. Now, notwithstanding I've talked about some building matters, in both building matters generally, building disputes generally, and matters involving matters of that kind, there is always the choice as to whether you proceed through the courts or whether you proceed through SAT. In the case of what I've identified already as scheme disputes, that is, issues which are really fundamental to the operation of a strata company, in defining scheme disputes under section 197 of the Act, I suspect that when the amendments went through last year, 2020 actually, 2 years ago now, the aim or desire was to try and make SAT in effect the forum for the purpose of determination of those disputes. But the Act does not quite go that far. In other words, you can still have a dispute involving matters which might otherwise fall within a scheme dispute and doesn't have to end up in SAT. So for example, I'm involved in a matter involving a retirement village, which is also a strata development, where there was an issue in relation to the engagement of the strata manager. And the outgoing, or I should say ousted, strata manager didn't take kindly when the company in general meeting resolved to boot the existing strata manager out and replace the strata manager with someone new. So the ousted strata manager, in order not to put the strata company offside, then launched federal court proceedings against the newly appointed strata manager to challenge the validity of the strata manager's appointment, which when you think about it is just plain bizarre. In other words, you're challenging the decision of someone that you're not prepared to sue. And the reason, if you think about it, that they weren't prepared to sue the strata company was because they wanted to be on side so that if they ever won their case, they'd be welcomed with open arms, because we didn't sue you didn't incur any costs, we didn't waste any money here, nothing to see here, we just got rid of that bad new strata manager. But hey, I'm back. Anyway, so surprise, surprise, the company in general meeting met again, decided that, or rather the new strata manager took the view that this was too much aggravation and will kindly step aside. So the strata company met again, general meeting, ousted strata manager, pick me, P, not on your life, so they've gone with someone else. So.
Did they sue that other company then?
No. Okay.
That was enough.
I realised at that point there was no good grace. It was gone. So the alternatives, as I say, in relation to these matters, which need to be considered, we'll look at why SAT first. As I said, the procedure is flexible. The question of costs, I touched on the question of the need or otherwise for legal representation. Costs necessarily go hand in hand with that, and it's an unavoidable fact of life that litigation is expensive, and it's an unavoidable fact of life that it's something you just don't want to embrace or be involved with. It's the last thing you ever wish upon anybody. If, however, you are in a situation where you've got into a dispute which is going to end up somewhere, may as well end up in SAT, because the general starting point for matters in SAT is that it's a no-cost jurisdiction. That's an expression that's used, that's not quite an accurate statement. It means that if there's a winner and a loser, as there would be in courts, the loser pays the costs of the winner. In SAT, you bear your own costs. So your exposure is what you're prepared to pay if you've engaged legal representation to take the matter through to either a point where it can be resolved by negotiation, at mediation, or it goes to a hearing and you get the final result. And that's a very important thing, because if you're talking about a substantive matter, then clearly the question of cost is going to be relevant. There is the capacity in certain circumstances for SAT to make an order for costs, but in general terms, you would have to have brought a hopeless case, persist in something when it was obvious what the outcome was going to be, or simply in the process delayed, took too long and wasted everybody's time. General starting point is that you'll bear your own costs, and that's all you'll bear, even if you're unsuccessful. The other point about a hearing in SAT is that although It might have been addressed by the building commission. When it gets to SAT, you're really starting with a clean slate. So whatever may have happened, the building commission doesn't bind SAT, rather SAT deals with the matters as it comes. In the case of planning, with which I'm very familiar, if it's a matter that goes to SAT from a decision of a local authority or from the planning commission or from a joint development assessment panel, then the outcome is just a fact. When it gets to SAT, it's a start all over again. So if the developer's application for development approval, what's going to be the greatest strata development of all time, has been knocked back by the planning commission or the JDAF, then if an application is then brought to review, in effect to challenge that decision, and goes to SAT, the hearing before the SAT proceeds from the start. And so, for example, I did a matter which involved a development of a microbrewery not far from a winery in one of the most desirable places to grow grapes in Western Australia. And the owner of the winery was organically certified, and the owner of the winery was petrified, literally, that the brewing process might release yeast enzymes which would drift across the neighbouring paddock and land on the vines, and so therefore contaminate the organically certified process and imperil, in effect, a lifetime's work. And in order to deal with that, as it turned out, we had 3 experts who participated, one from Sydney, the world's leading authority, who happened to be in Wales of all places, and a chap who ran a brewing course out at ECU. And as they all confirmed, it's a sealed process. Yeast enzymes cannot escape because the nature of the process is entirely sealed. So as a result, the concerns of the adjoining owner were completely dismissed on the basis there was no foundation for that, and ultimately there was an order for cost because there was never any evidence to the contrary. All of the experts had unequivocally said it's not a problem, but saying not a problem wasn't enough for the adjoining winery owner. All right, so if we can go then to the alternatives, there are alternatives. You can have your dispute the subject of arbitration. An arbitrator is a privately appointed person who, by agreement, is given the role or designation of determining your dispute. And there are lots of reasons why people would consider arbitration. The first most obvious is privacy, because the determination by an arbitrator is private to the parties to the arbitration and is not the subject of any wider publication. And in commercial disputes, and I can imagine often in relation to building disputes and certain builders, they're happy that the matter goes to arbitration because it can be dealt with within those confines. That really is the principal attraction. It's often said that arbitration is also attractive because it's more streamlined than court processes. I'm yet to be convinced by that. In fact, I've just finished day 1 of a 4-day arbitration today, and I can tell you it's bogged down with process. That's life, or that's my life. You can take the matter to court, again, depending on the seriousness or significance or the precedent value of the issue. And so you'd be aware in New South Wales of some of the apartments had cladding issues. They were sufficiently significant where you might contemplate, for the benefit of other developments, a determination by the court would be in everybody's interest, and that I readily understand. If it's a common or garden dispute in relation to a cracked driveway, that seems unnecessarily over the top. SAT is your forum for that, or you do nothing. And frankly, that's the choice of many people. Life is like everything else. You weigh up the risk, don't you? You weigh up the considerations, the level of importance. How important is this to me? Because there's no doubt being involved in the process whether it involves going to SAT with all the assurances that's offered in relation to flexible and we'll get there quickly and so on, or going to court, your heart's racing, your anxiety levels are rising, it's distracting, it's difficult. And many people can take the view, I can live with it. And I understand that, and in many cases that's what people do. But in strata disputes, the pathway is set for those sorts of disputes, if they're not going to go away, to, if they're building matters, go through the Building Commission to SAT, or if they're not building matters, to go to SAT on the basis of a scheme dispute, and it sets itself up as a forum designed to achieve what you would hope a specialist tribunal working with these areas would achieve. That is, as the Act itself points out, the correct and preferable decision, efficiently and at low cost. So that's SAT 101. The only qualification that needs to be added in all of that, of course, is the human factor. That is, that's the expectation as predicated on the Act. Whether you achieve that outcome often depends on how you populate the tribunal. And experiences with different members gives you different feelings about the outcome. But consistent with their aims, that's how SAT should be approached. Thank you.
Peter, I'm going to do Q&A, and I've got a question and I won't be long. So there's a member who sits on SAT that Aman Sahar.
Oh, are we still recording?
Do you want me to stop the
Oh
recording?
no, that's all right. Yeah,
You can see the recording after.
that's right. I know who he is, yes.
Yes. Now he says that if you're talking about building disputes, that you need to get specialist reports to go to SAT to make sure that, you know, that you, if they stand up, if the builder stands up and says, I have something to the contrary, you actually have something that's worthy of actually contradicting that report. What's your thoughts on that?
You can draw on the experience, dare I say it, and I've only ever appeared there once, of the family court. The family court has had a practice for many, many years of having a single expert. And what Dr. Sahar is addressing is what occurs within the usual adversarial framework. That is, the owner of the strata plan, in order to advance its case, gets a building expert who provides a report. Builder goes off and gets a countervailing expert to respond. You then set in train the processes where the experts have to meet, confer, provide a joint statement, see what's agreed and what's not agreed. SAT has the capacity, although it's seldom used, to be able to appoint a single expert in order to go out there, and the parties are then bound by the views of that single expert. So I think that's part of the answer. The other part of the answer is that the expertise of the members, including Dr. Sahar, is able to be deployed provided it's done so openly. In other words, it's totally inappropriate that if you have a hearing about a particular building defect and you find that when the members retire, one of the members said, I know all about that, I've been doing that for years. Now, what you really have to do is this, this and this. Now that's totally inappropriate. It's relevant for the member to have the expertise, but if the expertise is being brought to bear, it's got to be done in a public way, shared with the parties, so that everybody is addressed within the framework within which we're operating. That is, it's a hearing, we're both involved, let's share it. So you can do it either way. Yes?
Just briefly, can you just walk us through now, just supposing myself misleading here, we'd like to get in the SAT and pursue an issue with the building. Obviously, I know we have to put it in place, but what are we obligated to take? Just that reported defects or noted defects from a builder or something?
All right.
If you
This
just walk us through
is
that.
where the Building Commission is really has a consumer, protection is probably not the right word, but a consumer sense about it. So that you make a complaint to the Building Commission as best you can, describing what the issue is. The Building Commission, once it understands what it is and once you've identified who did the work, then appoints an inspector, and the inspector will go out, either with you or as guided by you, and get to grips with the particular problem. So the inspector becomes your evidence gatherer. So long as you've got a sufficient précis of what it is that you can lob at the building commission, the building commission has the investigative powers to run and take it further, rather than SAT, which in effect waits for you to bring the material to it. So there's a fundamental difference there. So in terms of what you need to bring to SAT, if the matter is referred to SAT by the building commission, the building commission's files just come across holeless bowlers to SAT. So the issue is already identified because there have been reports in most cases which give life to what it is that perhaps you couldn't get out in the right words that fit within the building compendium. You know what I mean?
But would we be obligated to inform the builder we're doing that?
Oh yes. Oh, of course. Because ultimately you want it fixed.
Yeah, that's right.
Oh, sorry, but you don't have to do anything. You make a complaint to the building commission. The building commission then contacts the builder, and the building commission deals with the builder.
So we just could make the complaint?
Correct. Yeah, not anonymously. I mean, you've
No.
got
So in that education kit, the last
Yeah.
book is about how your rights are protected, and that takes you through the process of actually lodging it with the building commission, okay? And then, you know, where they go from there. But, Peter, would you want to have some advice before you lodge it with the building commission? Like, would you maybe want to get some kind of...
Not really. As
No?
I was saying in answer to this gentleman's question, the building commission is fully equipped to deal with all of these things. It's not, as I say, it's not like the tribunal. You don't have to put your case to the building commission to persuade it to do something. You've just got to identify what the problem is for the building commission to see it's a building issue, and for the building commission to understand that there is a builder on its list that it can deal with, and it then investigates. That's what they're there for. That's what the raft of people down there are designed for.
We would, in theory, we'd be presented with a form, and we just put that.
Correct, yeah.
And that, yeah.
I'll send
That's
you
it.
I'll send electronic version, because the electronic version, it has all the links, so it takes you to all the forms that you need to fill out. Yeah.
Yes, one of you.
Same building.
My question is, if we have a case that's been referred to SAT, once they make a decision, can we do, and if they fund to the builders, is there an appeal process that the builders can take, or if they fund for us, is there a vice versa, you know, is there an appeal process beyond SAT?
There is a very limited right of appeal under section 105 of the State Administrative Tribunal Act. It has to be on a question of law. So if you're dealing with factual determinations, that's the end of the road for both parties. If you're dealing with, for example, the construction of a contract, which might involve a question of law, that might winkle itself out as an issue capable of going on to the Supreme Court. But very few matters go from SAT to the Supreme Court, except in planning matters for obvious reasons. I say obvious reasons because invariably it's the developer who still hasn't got what the developer wanted to get. Yes.
If you are putting a claim through first to the building commission, and they decide it's too complex, complicated, they want to show it to SAT, then you're not going to get any inspector out from the building commission to have a look at your claim before it goes to SAT.
Go back to the gentleman's question, if you did supply a whole lot of documentation which self-evidently demonstrated we're dealing with something bigger than Ben-Hur, yes, they would just refer it off. If, however, it's not clear, they would investigate before coming to that conclusion. So it's not very often they would simply refer it on to SAT without themselves having undertaken some investigation.
And if you have a lawyer sort of guiding the process, you would expect them to outline what forensic evidence you're going to need for
course.
SAT before the claim goes in.
Yes, because as I say, there's a fundamental difference when the building SAT. Once it's gone from the Building Commission to SAT, SAT's, although it's got the Building Commission file, it's waiting for the parties to pursue the matter, whereas the Building Commission, because it's got its separate investigative powers, will get out there, if it's satisfied, it can wrap it up, get to the point of making a building order. Whereas when it gets to SAT, SAT wants the parties to advance their respective cases. And that, as you say, probably needs, it doesn't have to, but you may wish to engage solicitors at that point. Simply to guide and to build the case that needs to be put to SAT in order to get the outcome you're after.
But we've actually done that. And we've got a strata manager who has resigned from the company and they no longer have a senior strata manager. Does that void the contract that a committee of owners would have with that company?
No.
Sorry, so the strata company would have had a contract.
The senior strata manager,
Yeah, but what is a senior, when you say a senior strata manager, you mean that person is an employee of a company?
Yes.
And the strata company's got a contract with the strata management company?
Yeah.
Right, the fact the employee leaves doesn't void the contract. Contracts made company to company.
Even if they don't have a senior strata manager, they're able to do it.
Correct. I mean, that might be a basis upon which the company, strata company that is, would convene a meeting seeking to determine the strata management contract for that reason. That's a separate question.
Actually, this will be my last.
That's all right.
The 6 years,
Yes?
obviously,
You want to talk about latent defects?
yeah, but what I'm saying is there's that 6 years. So, can I, when obviously the cut-off point is 6 years.
Yes.
So, if I go up on 5 years, 11 months, 20
No, it has to be lodged, and they've had to investigate it.
Well,
yeah.
I've got a matter which is...
Well, where's the cut-off date? Yeah.
Oh, okay, so there's two elements to it, or three elements to it.
Yeah.
One is the date's measured from the date on which the last work was carried out. And it must be brought within 6 years, which means in the case I'm dealing with at the moment, the complaint wasn't brought until the 364th day of the 6th year, or the 5th year as the case may be. And so, and in fact there has been a case in SAT about whether or not, and someone completed an online form on the last day or not, and SAT actually determined that electronically it wasn't received until the next day when someone in effect clicked on it, and as a result the complaint was out of time. The second point to make is that if it's a latent defect, so for example it might relate to ground conditions, that's not something for which time begins to run until there is a basis to know that there is an issue. So in other words, some part of the wall, some part of the wall of some part of the building suddenly collapses, and investigations are carried out, it's found that the foundations weren't as per specifications, time will run from that detection. So that's the second point. The third point is, often you'll get the builder to come back after the contract is finished, after the contract works is finished, maybe several years later while there's been ongoing correspondence, and eventually, reluctantly, the builder comes out and does something. 6 years will start again in respect of that work. So if the builders come back and attempted to fix any problems with the fix, 6 years run from when they did the fix, not from when the contract work was first carried out.
Substantial works.
Sorry?
Substantial works. So if it's substantial work, so
Like Dan Curry said, we keep getting promised, oh yes, we'll get back to you, We're at this stage now, I think we've got 12 months to go.
who's the builder?
Chap up in Kolkata.
It's usually a delaying tactic that they
They do,
use.
Yeah, so we've decided, we're going to present this to SAT.
Yeah, building commission first. Yeah.
And I think what you say is also unfortunately true, that is that it can be a tactic deployed by builders, particularly a builder who's been involved in the development of a reasonably significant complex, because as far as they're concerned, they were on risk the whole time that the work was being carried out. They've now eliminated the risk by having paid. And in some instances, dare I say, it may well be a single venture company. That is, a company established for the purpose of building that development. Once the development's finished, they've paid any tax or GST that they may have had to, and wound it up, disappeared. And any insurance that may have been around at the time probably went with it. So you're left at best with a remedy against the poor old registered builder, who in all likelihood isn't worth powder and shot in terms of suing. So sometimes delay is to be what all
Well,
delay
they
is
have
to be
come and
avoided.
done some work, but they keep, we'll get back. And that's why it's interesting on that window of 6 years, because obviously it goes out for another 6 years and they come back to address it.
Well, provided the work is not just, you know,
Polyfiller.
polyfiller on a hole, it's got to be some
Yeah.
substandard work.
Yes,
Yeah.
I understand.
And they will come and do the easy stuff and defer the hard stuff.
Correct.
So they'll, I know that sounds terrible to be so cynical.
No, we're all
So that
adults.
they'll come and do the easy stuff just to keep you quiet, and then they'll keep deferring doing the hard stuff, because, you know, that takes a lot of cash sometimes.
Yes.
Sorry, one more question. Just in relation to that deferring tactic, if we've been approaching builders for 4 years, trying to get them to the table to have the conversation and they're just not interested, and we're now accruing costs because we've been going to solicitors and we're going through the process, is there a possibility of getting SAC to award costs to us for that, the costs that we've incurred because they weren't mediated earlier?
Are you in SAT now?
No, we've got it's been referred from the Building Commission to SAT as we spoke.
Alright. The reality is that SAT can only address costs in relation to its own proceedings, not what's gone before. So, if it's taken 4 years to get there, SAT will say, with all due respect, that's not our problem. It's what happens in SAT from the kick-off until when it's resolved at their
So
concern.
would that include the solicitors and the reports and things that we've had generated to meet the requirements for the SAT hearing?
Well, if you're able to develop a case where it's apparent that the builder's attitude isn't based upon a genuine dispute and is truly about delay, then you do have a case in accordance with Section 874 of the SAT Act to ask for costs in relation to their behaviour. But the costs you've incurred to get to this point aren't ordinarily recoverable unless you've got a builder in that situation.
It's up to the SAT discretion, isn't it? It's up to their discretion,
Yes.
what sort of costs, or if they do, or how far they go back.
But it may be
It's
worth
totally
the
up to
cost,
SAT.
if you're looking at a $500,000 repair job, for example, it may be worthwhile for the Australian company to pay the $20,000 or the, you know, the report or something of that nature if the repair work is substantial, right? So in my document and on the building commission, they will say, you know, weigh up, if it's going to cost you X to get this to legal matter, would it be just as wise to use that money to repair the problem yourself? Now, and if it falls below 100,000, Peter, as well, is it going to SAT if it falls below $100,000?
Well, if it's a civil dispute.
Yeah.
No. SAT has no independent jurisdiction, so if it's below 75,000, it goes to the magistrate's court, then up to the district court, and then if it's above 250,000, to the Supreme Court.
All right. Any other questions?
Just a comment. I find it difficult in this day and age that these builders, who I don't trust and I've never had a very good relationship with over the years, can build something and just give a 6-year warranty. And because they just build something to last 6 years, and yet a commercial building is meant to last 40 years.
Right.
And they've got away with this 6-year warranty period for years and years and years.
Well, it's not the province of builders. The 6-year limitation is universally applied in respect to any disputes of any kind, whether you're buying a business, whether you're selling a car, any transaction which would otherwise give rise to litigation. the 6-year period applies to all actions, not just building
So it
disputes.
should be reviewed.
New South Wales, no, Victoria's 10 years, but every other state is 6 years or 6 months.
I'd just like to make a comment. I did an apprenticeship in the building and construction background. I was fortunate enough to work for a company that specialised in multi-storey work and government projects. The issue that I perceive in the industry today, when we did government jobs and multi-storey jobs, there was a clerk of works employed on that job. Now, the clerk of works was an independent person that usually had master builder qualifications. He had his own office, his own documentation. Now, he would adhere and make certain it's done to the correct standard and the correct building code. That's the biggest problem in the industry. The influx, people employ tradesmen, they give a cheap price, but if there's someone on that job that was responsible and signed off as a clerk of work. What happened a number of years ago, everybody got excited, different state governments threw out building inspectors, they threw away everything and let it up to the developers to do it themselves. Self-certified, and this is the big issue predominantly in Sydney and New South Wales. It's a disgrace because they just rolled over the different state governments and let people self-manage the industry. It happened in the States, it's happened all around the world. They went down this path and it's failed.
Yeah, certainly when the new Building Act came in 2011, that was a fundamental change between responsibility and application.
Thank you very much, Peter. It's much appreciated. I think we can all see by the way Peter has presented and spoken today that he's very good on his feet. And I've had Peter on the other side of cases in, I think it was the Supreme Court. I much prefer to have him on my side because not many barristers had advocacy experience in all the courts. And even if they have, are they good on their feet? Can they convince a judge of your position? Can they examine witnesses appropriately? Can they cross-examine the other side and cut through all of the nonsense and focus on the key points that somebody like Peter knows that this particular judge is going to sway this particular judge's decision or this member's decision. I cannot tell you how important that is to make sure you have the right barrister on board on your case. I've seen them, and sometimes, not to say too much, but you really need to know who you're briefing as your barrister. It's like going to your doctor, your solicitor, your GP is going to then refer you to a specialist. You want to know that that surgeon that you're being referred to is top shelf and will do a good job and a proper job. And unfortunately, because 90-something% of cases don't go to trial, they settle before trial, there's less and less barristers coming to the bar, I believe, who have this trial experience. And it's so important, and I really appreciate it. You can see the way Peter spoke on these various issues, pulling up these sections and these cases, you know, he's got the experience, so thank you very much.
Thank you very much. All right, just before you head off, the last things. So we have a number of new events coming up. So we actually have Professor Hazel Easthope actually talking to us about her recent research about navigating defects in apartments. New South Wales has a building commissioner. They are doing inspections of apartments. They are actually got a 5-star accreditation system which is working over there. We're talking to Matt Press from David Chandler's office about that. 10th of March, strata improvement loans. So if you have a major issue within your building, instead of raising the levies, one of the things that you can do is a strata improvement loan. Is it suitable for you? We're going to talk to Natalie from Macquarie Bank about that. And then on the 10th of May, Bronwyn Weir, if you're in the industry, you will know of Shergold Weir report that came out about 2.5 years ago. That was what Mascot Tower was an Opal Towers catalyst, right? That's why the Building Commissioner is doing what he's doing in New South Wales. So Bronwyn's going to have a Zoom event with me where she's actually, because the ABCB has put out a report, Australian Building Group have put out a report which says that there is $2.4 billion worth of construction defects in Australia. 1.3 billion of them are apartments. So this is a time to start to change. And Bronwyn's going to do a scorecard with me about each of the states and how they rate in terms of then actually taking on board those recommendations. So I can't do what I do without my sponsors. I would like to thank Equitas Lawyers, obviously, but I'd also like to recognise Greg Keat, put your hand up, darling, from Alliance FM. So Greg is my go-to guy for inspections. He inspected my apartment building. I now have got a specialist coming in to look at my car park because we're growing stalactites. And if anyone should know, a stalactite does not grow in a car park. My job is to convince my strata company to make us pay for the repairs, and that may go to SAT. But because they just don't want to acknowledge it, you know. But when you see a stalactite growing, it's an indication that it's an issue. And my builder's gone bust in debt. So
That's what builders do very conveniently.
yeah.
Time and time again.
Yeah,
And it's not good enough.
Pizarros is in that mix too. All right, so thank you for coming along tonight. I hope that you've enjoyed the session. I hope you're taking something away, yeah? If you'd like to become a member, you can come to these events for free. So I will send you out the membership form tomorrow. And I will also send you out the electronic version of the kit, okay? If I don't have your email, please email me, okay? Because my email address is on the kit, okay? And that way then I can send you the electronic version and all the information about what's coming up. All right. Thank you, Peter. Thank you, Martin. Very much appreciate your time. Thank you, everybody. Drive home safe.
Thank you to St John for providing.
Oh, and St John's. Thank you so much.